Imagine, if you will, a complex web, each string connected to another, forming a delicate balance. This, friends, is the U.S. legal system. Much like this intricate web, the United States legal system is a network of laws and regulations stretching across the nation, binding us all in a shared understanding of rights and responsibilities. At the heart of this network, pulsating with authority, is the United States Constitution. As the supreme law of the land, the Constitution lays the foundation for the entire legal system, establishing the principal organs of government and their functions, and defining the fundamental rights and freedoms of the citizens. Yet, the Constitution is not alone in this vast web. Joining it are the federal, state, and local laws, each playing their part in shaping the legal landscape. Federal laws, generally, have nationwide applicability, addressing issues of national importance like immigration, bankruptcy, or copyright. State and local laws, on the other hand, tend to deal with matters closer to home, such as property, family, and criminal law. But laws alone do not make a legal system. Enter administrative regulations and case law. Administrative regulations are rules made by government agencies to carry out the intent of the law. They fill in the gaps, providing the details necessary to implement and enforce legislation. Case law, on the other hand, is the collection of past legal decisions made by courts. When judges have to make a decision on a case, they look at how similar cases were handled in the past. These precedents guide their judgment, ensuring consistency in the application of the law. So, you see, the web of the U.S. legal system is vast and interconnected, a delicate balance indeed. Each strand, whether it's the Constitution, federal, state, or local laws, administrative regulations, or case law, plays a crucial role in defining the legal boundaries that govern our lives. As we navigate this web, we'll explore how these elements interact, their impact on our everyday lives, and the ethical considerations they raise. Stay tuned as we delve deeper into this fascinating world. Now that we've got the basics down, let's dive into the heart of the matter: ethics in law. Our journey begins with the first school of thought: natural law. This is the belief that certain laws are universal and unchanging, regardless of human-made laws and regulations. Think of it as a moral compass guiding our actions. For instance, the concept of natural rights, like life, liberty, and property, is a cornerstone of natural law. These rights are inherent to all human beings, irrespective of their nationality, race, or gender. They're not bestowed by any government, but are intrinsic to our very existence. Next, we encounter legal positivism. It's the polar opposite of natural law, asserting that laws are created by human agreement and are not inherently moral or immoral. The classic example is traffic laws. There's nothing natural or universal about driving on the right or left side of the road. These laws are purely societal conventions, agreed upon to maintain order and safety. Legal positivism argues that the validity of a law rests on societal agreement, not on any moral or natural rights. Lastly, we have legal realism, the belief that laws are influenced by the judges who interpret and apply them. This school of thought insists that law isn't a fixed set of rules but evolves based on the personal views, experiences, and biases of the judges. Take the example of a judge deciding a case on free speech. Their decision could be swayed by their personal beliefs about the importance of free speech, their interpretation of the Constitution, or even their perception of societal needs at that time. Remember, these schools of thought aren't mutually exclusive, but rather, they coexist, contributing to the ethical landscape of the legal system. We've talked about the legal system. We've touched on ethics in law. Now let's bring it all together with judicial activism. Judicial activism is a term that sparks lively debate in legal circles. It refers to judicial rulings that are perceived as being based on personal or political considerations rather than on existing law. It's a concept that sits at the intersection of ethics and the legal system. On one hand, judicial activism can be seen as a necessary tool for promoting justice. It allows judges to step in when laws are unjust or when they fail to address pressing societal issues. For instance, during the Civil Rights Movement, the Supreme Court used its power to strike down laws that enforced racial segregation, a clear example of judicial activism working towards justice. On the other hand, judicial activism is often criticized as an overreach of judicial power. Critics argue that it allows judges to legislate from the bench, essentially bypassing the democratic process. They point out that judges are appointed, not elected, and they should interpret the law, not create it. This perspective views judicial activism as a potential threat to the balance of powers, one of the bedrock principles of the U.S. Constitution. The debate around judicial activism is a perfect illustration of the tension that can exist between law and ethics. Law is about rules and regulations enforced by the state. Ethics, on the other hand, is about moral principles, which can sometimes clash with the letter of the law. When a judge decides to rule based on their interpretation of what is just rather than what is written in the law, they are navigating this tension. Judicial activism, then, is a double-edged sword, a tool for justice, yes, but one that must be wielded with caution. It's a reminder that while the law is a powerful instrument for maintaining order, it's also a human institution, subject to our interpretations, our biases, and our aspirations for a just society. Ethics and law, two sides of the same coin. But how do we make ethical decisions in the face of complex legal dilemmas? The ethical decision-making process is a step-by-step journey to help navigate these challenges. First, we identify the ethical dilemma. Let's imagine a scenario. A law firm's client is a company accused of environmental pollution. The company offers a hefty sum to the firm to ensure a favorable outcome. Is it ethical to accept this offer, knowing that it might impact the environment negatively? Second, we gather information. This involves understanding the facts, the relevant laws, and the stakeholders involved. In our scenario, the law firm would need to research the extent of the pollution, the environmental laws in question, and the potential impact on the community. Next, we evaluate the alternatives. What are the possible courses of action? In this case, the firm could accept the offer, decline it, or propose an alternative, like helping the company improve its environmental practices. Then, we make the decision. This involves weighing the pros and cons of each alternative. The firm might consider the financial gain against potential damage to its reputation and the environment. Afterwards, we act on the decision. The firm would then communicate its decision to the client and take the necessary steps to implement it. Finally, we evaluate the decision. Was it ethical? Did it serve the best interests of all stakeholders? This reflective step is crucial to learning and improving future decision-making. So in this hypothetical scenario, the law firm faces a complex ethical decision. By following these steps, they can navigate this complexity, ensuring their actions align with their ethical principles, and not just the letter of the law. And there you have it, the ethical decision-making process, your compass in the complex world of law and ethics. We've journeyed together through the intricate web of the U.S. legal system, delved into the world of legal ethics, and navigated the path of ethical decision-making. We've traversed the terrain of the U.S. Constitution, the bedrock of our legal system, and explored the interplay between federal, state, and local laws. We've examined the role of administrative regulations and case law in shaping the legal landscape, and dissected the ethical underpinnings of law with a foray into natural law, legal positivism, and legal realism. Ethics, as we've seen, is not just a sidebar in the legal system. It's at the core, shaping judicial activism and influencing the course of legal rulings. The ethical decision-making process, as we've discovered, is a step-by-step journey. It begins with identifying the problem, gathering information, and evaluating the ethical issues involved. It then moves on to considering possible courses of action, making a decision, and reviewing the decision. This journey of understanding would not have been possible without the works of numerous scholars and legal experts. The U.S. Constitution, our primary reference, is publicly available at the National Archives website. The federal, state, and local laws can be found in various law libraries and online databases, such as the Legal Information Institute at Cornell Law School. Our exploration of legal ethics owes much to the works of eminent scholars like John Finnis, H.L.A. Hart, and Oliver Wendell Holmes, Jr., whose works can be found in legal journals and publications. The steps of the ethical decision-making process were derived from the model proposed by the Josephson Institute of Ethics. Remember, in the realm of law and ethics, knowledge is power, so arm yourself with understanding and navigate the web with confidence. How does the U.S. legal system, with its intricate network of constitutional, federal, state, and local laws, administrative regulations, and case law, strike a balance between providing structure and allowing flexibility for societal evolution and individual rights? Can you discuss a real-world example where the ethical principles of natural law clash with the legal framework established by federal, state, or local laws? How do individuals and institutions navigate such conflicts, and what implications do they have for the interpretation and application of the law? Judicial activism is often lauded as a means of promoting justice, but criticized for potentially overstepping judicial boundaries. Can you provide examples of landmark cases where judicial activism has had significant societal impacts, both positive and negative? How do judges balance their ethical responsibilities with their duty to uphold the law impartially? Thank you for joining us on this enlightening journey through the intricate web of the U.S. legal system and the ethical considerations that underpin it. As we conclude our exploration, remember that the law is not static, but evolves with societal values and ethical principles. By understanding the foundation of our legal system, the interplay between laws and ethics, and the ethical decision-making process, you are equipped to navigate the complexities of law and ethics with confidence. So, arm yourself with knowledge, continue to explore, and remember that in the realm of law and ethics, knowledge truly is power. Thank you for watching, and until next time, stay curious.